Yes, I'm grateful.
Lordship, I'm for the petitioner in this matter. We're withdrawing this writ petition and the instructions are given hereby. A copy. Your Lordship, we had filed this writ petition in 2023 for an amount which was wrongfully withheld by the revenue. Yes, Your Lordship. Lordship, Lordship, no interim orders then. Grateful, Your Lordship.
My lord, this is also for withdrawal. দিয়েছিলাম তো
আমাদের একটা কপি
দিস দ্য সার্ভিস কপি
দিচ্ছে না এটা
my lord, for withdrawing the petition and availing the amnesty scheme under GST Act. Grateful to you.
একটা কপি দিন ও তো স্টেট এর একটা কপি দিন
State respondent because other respondents are also.
We are for this CGS.
Grateful.
I want to withdraw the petition.
Withdraw.
No, my lord. There is no interim order. First time. My lord, instructs. Withdrawal instructs. Grateful, my lord.
My lord, I am for the petitioner, my lord. My lord, similar prayer, my lord, praying for withdrawal of this application. My lord, yes, yes, your lordship. There was any. Yes, your lordship. Your lordship order was there, my lord. Yes, sir, yes. Sir. My lord, my lord. My lord, for availing amnesty scheme, my lord. Yes, your lordship. My lord. My lord. My lord. I'm grateful.
Your Lordship, petitioners. Your Lordship, this is for extension of interim order. It was passed in the year 2022 on 25th of April. And thereafter, it has been extended time to time. Your Lordship. Upon payment of 20% under section 112, the demand was stayed. The pleadings are complete.
Meetings are completed. Exhibits have been filed.
Fine.
Every time it's on board.
Similar.
Exhibit
Affidavit complete. It is same, Your Lordship, but the main order was passed on 16th August 2022. The main interim order. The main interim order was passed on 16th August 2022. Yes, Your Lordship. Same petitioners, but different years.
Lordship, I'm appearing for the petitioner for extension of interim order. This matter, Your Lordship, pertains to section 168A, the notification. So no affidavit has. Affidavit given है? हाँ, तो issue तो जानी नहीं, लेकिन तो direction है.
Central level.
Your Lordship, on 13th November
My lord,
20.
my lord, we have
No, 13th November, Your Lordship. That is the principle. Yes, and further extended, Your Lordship, on 28th January.
time may be extended, Malad, we have drafted is, but Malad couldn't.
Phonex.
No, no. Who's in?
Malad, item number 11. But this is also Malad 168A. The 22nd of November, Malad, order was passed. Then Malad, but I can't.
Grateful, my lord.
3 weeks after the summer vacation, liberty to mention. Reply 3 weeks and till disposal of the writ petition.
I'm grateful to your lordship.
Yes.
Grateful, my lord.
Lordship, I beg to appear for the petitioner. This is for extension of interim order. The interim order initially granted on 3rd January and further extended on 20th January is expiring in the end of April.
Same extension. Till
Same
disposal.
168A matter.
Till disposal. Opposition extension.
Opposition, your lordship.
Bolche na. Liberty to mention. Yes.
Grateful to. Lordship, I am for the petitioner. A similar prayer I have as the same as item number 12, your lordship. It's a 168. Interim order is expiring on in end of April.
Initial order 3rd January 2025.
Your lordship, 3rd January. Same.
Subsequently extended and is valid
On
till the
January.
end of this month. Be extended. সই কোথায়? জুড়ে দিয়েছো তো তুমি। এর ভেতরে সই করার দরকার ছিল তো। এর এখানে সই করবে তো। এখানে সই করবে তো।
Number 14.
I am for the company in this matter.
দেখি স্টে ছিল না এটা?
That is
You have
item
been-
15, your lordship. Next item. We have, because of our financial constraint, we have made some payment. And we undertake to make the payment. We are ready to approve
Yes.
before the certificate of.
There is your affidavit by the officer in charge.
Lordship, I am appearing for the officer in charge, Lordship. Affidavit is not completed, but compliance report is there.
Oh, I directed an affidavit to be filed, madam.
Lordship, kindly allow, we have received this brief just last.
What brief? Did he, not for you, madam.
Lordship.
Where is the officer in charge? Why did he not file the affidavit?
Lordship, he has just handed over me the compliance report yesterday only. And
What does it record?
it's record that he have arrested the person. The warrant has been executed. Lordship,
Yes.
kindly go through the report, Lordship. 14 and 15, the same one.
What is this? You give me. No, I've got your report. I've got your report. Wait. No, which order they had surrendered?
Your Lordship, item 15.
That is different.
Next time.
Not this matter.
Your Lordship, we surrendered for both of them itself, and Your Lordship, we made part payment, which I submitted before Your Lordship, and we undertake that.
I did not grant him so far as this matter is concerned. I had clearly recorded in the other matter he was gone. How could the police enlarge him on bail in this matter? You did not approach this court, madam, so far as this matter is concerned.
Your Lordship, in this, we made before the certificate officer and to the police also, we made a representation to allow us installments and to make the payment. We made a payment. The amount is very less, but we are ready to.
What is the amount, madam?
25,000 payment has been. Your Lordship,
No.
Your Lordship, we will make by this week, by today itself, we'll make another payment, Your Lordship, and next week we'll make another payment, Your Lordship.
What happened, Lordship? They are
Madam,
not,
this is not in compliance with the order.
Lordship.
This is not in compliance with the order. I'm not recording anything today.
Lordship.
I'm returning it to you. File an affidavit.
Lordship.
And madam, you take steps in the matter.
Your Lordship. I'll file a proper application, Your Lordship.
No, you pay.
I'll pay and make an application to that effect. In what manner and what dates the payments will be made.
Madam,
And
this will not do, madam. Madam, the payment,
Lordship, the
gratuity, the payment has to be made.
Your Lordship, I bow down to Your Lordship. This is.
How can you take away someone's gratuity, madam?
Your Lordship,
What is this business going on? If a business does not permit payment of gratuity to workers, that business cannot continue, madam.
This business is not continuing. The mill is totally closed. In the word,
understand a
in the
business,
verge of
a business
closure.
which does not permit payment of gratuity to workers, how can it continue?
Your Lordship. We will make sure the payment is done.
Can you sit in a luxury car and move around at the cost of a gratuity payable to employees, madam? You will be knowing the situation better, madam,
Your Lordship.
because what all is apparent and what is shown may not be the true picture.
Your Lordship, the mill is
But
actually
so far as maybe they are facing difficulties, but that does not necessarily mean they'll hold on to this.
Your Lordship, they will not hold on to it. We undertake that the payment shall be made in installments. Your Lordship, we will make the payment within a month.
I do not know. Whatever you want to do, you do. I'm
Your
just
Lordship.
making it not today.
Your Lordship.
এটা ফেরত দিয়ে দাও.
The concerned director was produced before the certificate of.
He did not. Why did he enlarge him on bail? I did not grant him liberty. So far as this matter is was concerned.
I am not granting the bail.
Yes.
Not granting. I am.
Yes,
Yes.
I am not
Certificate
granting.
officer have granted the bail. The police arrested the person. Or should the report says so, Lordship.
No, sir. No, madam. Report does not say that.
Before the certificate officer.
Go through the report.
And-
Once again. দেখি রিপোর্টটা দেখি.
Lordship, he making the undertaking.
দেখি
He should pay.
দেখি দাও.
In spite of that, no payment has been made, Lordship, till today.
Lordship, on 16/4, Lordship, the last para, Lordship.
Certificate officer is not the granting
They
authority
were
for
in
bail.
charge on personal recognized bond and they appeared before the
It is the
certificate.
police who has granted him the bail.
Yes.
By treating as if in this matter a similar order has been passed. Miss Pandey has understood the entire thing because she knows this.
Your Lordship, I have no role in this. As soon as I had moved in item 15, I had informed my
You ought to have approached this court, madam.
So there's
You ought to have approached this court.
Because
This
no
is,
payments were made.
this is, madam, getting an order and then misusing the order for some other purpose.
Your Lordship, that has not been done by us.
Yes.
I had informed them that a payment is due in this.
When will you
and
pay?
Your Lordship, by today we'll make some payment, and by next week we'll try to make some payment.
A compliance report has been filed on behalf of the officer in charge, Hare Street Police Station. From the above, we
Bow down, Lordship. Item 50. Your Lordship, in this, we had filed a review application. We surrendered before Your Lordship Your Lordship, in this, the matter over here is the entire amount of principal and simple interest has been paid, Your Lordship. The calculation that was made on compound interest, that is of 1,72,000. Your Lordship, we had surrendered. We had filed a writ application pertaining to the new orders passed by the certificate officer on the ground, Your Lordship. There were two grounds on which we had filed an application before the certificate officer, because the compound interest has been calculated on principal plus simple interest, whereas the calculation has to be made only on the principal, Your Lordship. Your Lordship, there are judgments of this honorable court that it has to be done on the principal only and not on principal plus interest, Your Lordship. But they have made it on the principal plus simple interest, Your Lordship. Your Lordship, as per us, the amount that is on compound interest, we had made an application that it should be on 6%. This is the calculation that has been made by us. The person who is handling is facing CID. Because of a coordinate benches order. So he has lost the control. Lot of issues. Your Lordship, as per us, 36,000 is the amount on compound interest. We are ready to pay that amount. We undertake to pay it within a week, Your Lordship.
Lordship, may I file the compliance report here?
He was undertaking before the certificate officer lordship within 24th this month payment will
That
be made.
was, your lordship,
You see
under
the
coercion that
aspect.
was done.
Yes,
Your lordship, we have given undertaking.
undertaking the payment will be made. Yes.
No, no, your lordship, this is
Can you see the
this is the
undertaking?
letter given before the certificate
matter
officer,
also
the
see.
previous matter, your lordship. Your lordship, previous matter, this is the letter which I had handed over, your lordship.
Lordship, can you see?
দেখাচ্ছে দেখাও একবার undertaking কিছু দিইনি your lordship no undertaking to
Yes, matter, Lordship. All director has been signed.
this is your lordship I do not have knowledge of it if at all it has been done it is under coercion because your lordship because
What
they,
he is submitting?
yes your lordship before the coercion set your lordship coercion why I would say it because he is not even deciding
His advocate
matters
also
on
present, Lordship.
he's not even in the next matter I have filed a writ application wherein I have stated that
And this matter also he is undertaking that within 24th. Yes, and this matter also can you see, Lordship?
your lordship as
This matter also can you
as
see, Lordship,
us
within
36
24th today. Lordship, payment
36,000 is the admitted amount by us. We have filed a writ application as
Can
to
you
the
see
new
undertaking? Within 24th. That's one 3 possible.
your lordship in para 27 and 28 of my writ application, your lordship, I have stated that it is under coercion. They have taken that. Ashok Kumar Sardar.
Yes, that means today. No payment has been made.
Your lordship, I have filed a writ application, your
Lordship
lordship.
directed the concerned police station.
Your lordship,
Certificate officer is not the authority to
your
say
lordship, I have filed a writ application challenging the order passed by the certificate officer, your lordship. And I have stated that it is under coercion. They have taken that undertaking. Your lordship, kindly appreciate the amount has been made calculated on simple interest as well. We are ready to pay the amount which is on the principal, your lordship.
Public demand recovery.
Your lordship, a coordinate bench's order is also there that it has to be on the principal and not on simple interest and principal, your lordship. Your lordship, a writ has been filed to that effect. And in para 28, we have stated that it is under coercion they have taken it, your lordship. Your lordship, we are ready even today to make the payment, which is the admitted amount, your lordship. Your Lordship, but we are ready to pay the admitted amount, Your Lordship, which is undisputed compound on account of compound interest, Your Lordship, the amount. Lordship, the certificate officer's order says that I have already issued 3 warrants. So I am rejecting your application, stating that it has to be on the entire principal amount. It can't be on principal plus simple interest. Your Lordship. Your Lordship has decided the entire writ petition because Your Lordship has made a remark that it cannot be done. Your Lordship, kindly expunge that remark. Do not make only my submission to that effect that a writ has been filed, because my writ becomes infructuous after Your Lordship passes an order. Same bench, coordinate bench, is making a remark to that effect. Your Lordship, the 9th April order passed by the certificate officer, he has not considered any of the matters. He has been stated, you give the undertaking or else you will again be arrested. So what, is that not coercion, Your Lordship? I'm asking this question to myself.
Lordship, this matter may also appear on 2nd of May after 3 weeks.
Your Lordship.
Lordship. No. Lordship.
No, Lord.
Lordship. Let the yes.
Sincerely obliged.
And Lordship, in item number 14 also I am for the petitioner. No, Lordship.
Lordship, the officer in charge will be released, Lordship, or
Lordship, kindly my name be recorded, Lordship. Lordship, kindly my name be. Lordship. Yes, Lordship, I could not reach. My health is
Lordship, one indulgence I will pray, Lordship. Let a copy of contempt be supplied.
ওর মধ্যে লেখা আছে
Contempt copy.
ওই নাম স্লিপ দিয়েছি 14-15 করে
Lordship, contempt copies both 14 and 15 may be supplied. I had written to my learned friend as well to supply a copy of the contempt.
We have not received the copy of the contempt, Lordship. If
Not
on the
necessary.
basis of the
Your Lordship, we are not a party. We intervened in the matter by filing an application wherein we have stated that we do not even have the contempt copy. So the cause title of the writ petition was only made, Your Lordship. Your Lordship, because the entire burden is upon us to satisfy Your Lordship how the order has been. Your Lordship. Had it been isolated, this it would have been different.
Lordship.
Your Lordship, every matter the certificate officer is, and there is a caucus. There is a caucus involved in it entirely. If the CID properly investigates, everything will come out.
Lordship, may I get a copy
From
of the
consulting
contempt,
party
Lordship?
to certificate officer, everything they are involved.
Yes.
Yes, Lordship, statutory appeal is there.
Your Lordship, we filed appeal. Appeals are not being heard. Your Lordship, that I bow down. There is nothing done by the.
He knows, Lordship, in several matters, Lordship, he prepared an appeal. An appeal also dismissed.
Lordship,
Yes, liberty is always.
Lordship,
They have right to prefer. Yes, Lordship.
Lordship,
Always.
Lordship, may I indulge us to get a copy of the contempt, Lordship, in both the matters?
Not necessary. He is not the alleged
They are
contempt.
not alleged contempt, Lordship.
No, that is why I am appearing. I'm as
Prepare
the
the report, Your Lordship,
no,
without the
report
cost
was already
title.
that,
না,
Lordship.
তোমাকে affidavit এ করতে হবে, হ্যাঁ।
তোমাকে পরের দিন আসতে হবে
না, আসতে হবে,
ওই
আমাকে
যতদিন
release-
চলবে
আমাকে release করেননি।
I'm appearing on behalf of respondent number 1.
My lord, I'm praying to withdraw this application. Only small submission, if your lordship record it, only one. No, kindly. Page 24, I have. I'm not saying, my lord, only record I am filed a writ petition against the adjudication order and therefore I am withdrawing this application. That is only one sentence. Only one sentence. No.
But there was no stay order.
No, I'm not going. I'm saying my submission very small. I have filed a writ petition. against this adjudication order, and therefore I am praying to withdraw this. Page 24. No, writ petition against show cause notice, this application against adjudication. And page 34. And in the instant application, we have challenged the adjudication order. And now we have filed the writ petition. তুমি এখানে কেন? হ্যাঁ? writ petition ফাইল করেছি তো। হ্যাঁ হ্যাঁ। Yes. Page 24 of the application. Page 24 of the application. Yes. No, no, I'm not withdrawing the writ petition. Writ petition is pending. I'm not only application I'm withdrawing. I'm withdrawing only application. October. No, I have already filed a writ petition against this order, separate writ petition. Yes. I'm Lordship. Yes.
We have prepared our affidavit in opposition to the writ petition. May I file it? Phone number, my lord, 2, 3. No, P4 and 6.
Please, we have not received any copy.
We'll serve a copy.
Only. Yes, sir. Only small indulgence. Only small indulgence. We have already filed a writ petition against this order. Okay, I'm grateful.
Copy served, sir.
Huh?
Copy has been served already.
No, we have not received. I'm grateful.
Reply.
Reply भी file होगी.
আমাদের রিপ্লাই দেখতে হবে। We have writ petition number 8824 of 2025. 8824 of 2025. বাহ, সবই দিয়ে দিল তো। I'm grateful.
My lord, I am for the state, my lord.
My lord, I am appearing on behalf of the petitioner, my lord.
And the respondent number 3, the certificate of the officer, as per your court, your lordship's order, he was appearing on the last occasion, and your lordship was keeping personal appearance, my lord.
My lord, my humble submission before your lordship is that there is a direction your lordship was given on the last day before, that is 4th April. There your lordship directed the certificate officer to take instruction.
Appearing today, he has not come to this.
I will be there, my lord. I'm extremely sorry. On the last occasion, I was not present, my lord.
This matter is pending before the NCLT, my lord, and no development has been done, my lord, there. No assets has been sold out. My lord, the petitioner can go before the appropriate forum, my lord.
My lord, now they are staying.
Then kindly give me the application. Liberty to no, my lord.
I am obliged, my lord. Hey, take it, guy.
Lords.
Where were you? I was invited by this court. There is here. No, you were not there. You were not there. Yes. When you take orders passed by the court so lightly, you appear beyond the order to the appeal court. The appeal court returned you the appeal. And the court, before appeal, whatever was there in your hand. You see that only that record again. Yeah, please understand this. It's a modern manner. You're taking only because of it.
Yes, my lord.
Under secretary, government of India, paragraph 8, 9, and 10. It is very important. I want to put, right? Yes, the judge that the petition is dismissed also. That is in the annexed in the Annex 1. That Supreme Court filed the petition and that is dismissed. The petitioner, it is filed a petition and before the Supreme Court, and Supreme Court on that ground dismissed, and that has vanished in the deed.
না না আমরা করিনি যা তো
No. What was that? Again, petitioner is again petitioner. That is not. He put
another matter.
Proceeding the appeal, I am presenting in the appeal court.
That is what? That is annexed in the. That is.
Yes, madam. Liberalized pension scheme. Pension scheme. Yes, madam.
But they now come and say, transfer is early. No.
Madam,
Yes.
madam, kindly see the first paragraph of the office memorandum, madam. Achha.
I shall understand facts. I shall explain the law. I shall explain the report. I shall explain. Was I had decided based on at least what was given. I do not understand because lack of clarity whether was green what. So I come and say whether this was now paragraph take up the report here. By virtue of the article, say we go that further. I do not see this.
হ্যাঁ লেখা আছে repeatedly
Yes, being the pension is enjoying the order but the above the pension has been transferred. Further submitted the same transfer I the above option twice in United States. Levels are pension in the power transformation. The terms decide option are divided to get the power transformation. What time is submitted W loss square? Submitted by that was not by that is not the logic. The logic whether that was expected. Sorry, or not. But getting today, get time for us. I said explain. Was going to answer to the question. I further submit that. Last minute has not been marked. Has not been marked. The HCI Implementation. No benefit under the above memorandum has been granted to the good transferee. The good office memorandum, Mr. Singh has referred to the lordship for
May I just show this office memorandum once more? No, my lord, kindly takes up the memorandum, 1987 memorandum once, my lord. That will explain, my lord. Kindly takes it up, my lord. My lord, I will give the copy, my lord. Paragraph, by first paragraph, my lord. Kindly takes up, my lord, the first paragraph. The undersigned is directed to state that the central government employees who are governed by the Contributory Provident Fund have been given repeated options in the past to come out of the pension scheme. The last such option was given by the Department of Personnel, suggestion dated 6th of June 1985. However, some central government employees still continue on the CPF scheme. This shows it was also given in the past, my lord. Now, when I filed the writ petition, my lord, I did not annex this memorandum, my lord. I didn't have a copy of the scheme, and I was aware that they were enjoying these benefits. I had filed the writ petition. Thereafter, Justice Joint Officer asked him to file a supplementary affidavit, my lord, disclosing, my lord, whether this scheme was extended or not. They did not file, my lord. Justice Kapoor also gives the same direction. They did only, my lord. At my lord's instance, this affidavit has now come, my lord. My writ petition prayer, my lord, is that, my lord. That is what my case is. That is the discrimination, my lord. Given special benefit given to a particular same. This is what has happened.
No benefit has been given to the transferee. Well, how is memorandum?
My memorandum is not the case. Liberalized pension scheme is my case. That's the writ petition. Kindly see my prayers.
No, but I shall explain what the judgment of the judge.
Initially, Mr. Chattopadhyay say he has no knowledge. Only central government has the knowledge. His client knows nothing, my lord. Now the central government is saying in my favor. Now he's going to defend the central government.
That's what I have gone to the you got that. But I have gone, but I have tried that. No, but there's a, I mean, there, I said, no.
No, this one is correct. I am bound by my clause. I cannot say no, this finding.
No, yes, I'm kind of funny, but एक तो हमारे जाएगा दिन नबी
अभी ठीक है सुनिए ठीक है ठीक है सुनिए
But one thing I must, because I'm finishing it off, but I shall give a 2-page note. You also kindly consider it. No, but otherwise, no.
I cannot accept any further.
But note, yes, but note after the lordship judgment. But only limited point about the memorandum. No, I know I don't want to reopen that. I want to reopen. I know, my lord. After the lordship judgment, the lordship's observation is there. That up to that portion I shall give. From that portion, 35. Yes, I'm coming. It would, as it appear from the above, the recent stand of the respondent number 1 seeks to somewhat contradict the statement made by the respondent in paragraph number 4 of the affidavit of petition, where it has been specifically stated that the benefit of liberalized pension scheme transferees have been granted by the central government in terms of provision section 12A of the Commission Act 1964. This admitted portion is act just given. I'm just reading paragraph. I'm just coming. But this is admitted portion. If I accept the stand taken by the respondent number 1 in this affidavit by ignoring the recent disclosure, then I have no hesitation to mind to contradict that the depositionists are being discriminated, since there is otherwise no distinction between the state government depositionists who later observed in respondent number 1 who transferees
whose service was transferred on the basis of the order passed in terms of such and such, and in such case, the respondent number 1 is obliged to ensure that the liberalized pensions is also extended to the pensions. Your Lordship's observation is there. Now, Your Lordship, Your Lordship's finding is there. But thereafter, Your Lordship has been pleased to consider add the Government of India to give a further disclosure as to why, as to the effect that the office memorandum is applicable to them. If Your Lordship holds, even if there are judgments, that if a person is availing the CPF scheme, if he wants to go to file and get chance of getting GPF scheme, even after getting option backwards, he cannot ask, there is a right to get option doesn't exist. Supreme Court judgment, I have two judgments, Your Lordship, kindly consider that, then Your Lordship pass them. No, my Lord, no, Your Lordship, kindly consider. I'm not re-arguing. Supreme Court has said that the question of law, because this right has been given to them by a granting of amending of act. Supreme Court has clearly dealt with the point which, but maybe available. But maybe, as Your Lordship, I am holding that may be available as per Your Lordship judgment. But where is the option? He has to file an option then. That I cannot.
No, I have to return all money, my lord. I don't get double benefit.
That cannot by Supreme Court judge. That portion I said I want to rely with. No, this will be in the air. If Your Lordship holds that they are entitled to, without any option they cannot. No, you must kindly consider if your observation. Follow Your Lordship. But appeal court's order I am just reading. Appeal court's order I am just reading. I am just reading. As well. अपने की एदिके असुन नामी जैक का दोकान आया क्यों ना? हम थे। appeal court.
Not competent means.
Well, appeal court's order
Didn't.
on 9/4/2024 in paragraph 4.
Yes.
Paragraph 4, may I read
From
that?
3, my lord. From 3, kindly from 3.
বলো না ফিটা ওকে
আপনি তো main point টা ছেড়ে দিচ্ছেন তো।
We request the learned judge,
Yes.
single judge,
Yes.
paragraph 4, my lord, the appeal court's order.
Yes.
But paragraph 4, my lord, have your lordship got that? The 9th April
Yes, yes.
2024. You must kindly come. We request the learned single judge to revisit the issue on the basis of the disclosures to be made on the added respondents and to dispose of the matter finally after giving a reasonable opportunity of being heard to the parties. My lord, therefore, my lord,
On the disclosure only.
Disclosure only.
disclosure only
Nothing more.
by
No.
by the applicants.
Yes.
Yes.
No further disclosure permit.
Further disclosure. I only rely on that.
Yes. That's why I'm hearing you, Mr. Chattopadhyay. I'm permitted to argue. You see, Mr. Chattopadhyay, today you cannot, in the guise of this order, reopen the entire issue. That has not been touched by the appeal
I am
court.
not reopening. I am only submitting with your lordship. Your lordship's specific query was the judgment in paragraph 35 and 36.
And you have been given opportunity that the decision taken that the appeal court, you will be entitled to raise all points again.
Again.
But the court did not set aside the order. So therefore, I cannot reopen it. I cannot revisit the entirety. Revisit only on the basis of the disclosure.
Well, I am on that.
Yes.
Only on that. I shall not argue much. You also kindly hear me.
You see, whether there has been discrimination or not, there is no appeal on that as of today.
There is an appeal. I have filed an appeal.
Correct. You have filed that appeal and the appeal court said I am not deciding that.
No, appeal court said yes.
No, that point has not been directed to be revisited.
No. Appeal court said if I can argue.
Again come back. Yes. Correct. So as of today, there is no appeal on that point. I am stopped, Mr. Chattopadhyay, legal aspect. I am stopped from revisiting that issue.
That issue.
Correct. I cannot if I want to also. Because Mr. Sinha will say, how can you do that? Because you have already decided this issue. You cannot reopen at your whims and fancies. I cannot change it.
No. But only thing is this, my lord. After your lordship.
What will I decide, Mr. Chattopadhyay? I will decide that disclosure. And on that disclosure, what difference it makes.
Yes.
Only on that.
Only on that. But only that point, but I am just coming. Your lordship kindly come to their affidavit. I want to read their affidavit.
No. Their affidavit, they will read. You want whatever you want to submit, you submit. Further reading of their affidavit is not necessary.
But their affidavit, only
Which?
their affidavit, Government of India's affidavit.
They already placed it. How many times you will place?
But I have not placed it.
Only that paragraph is necessary. The Government of India, if the Government of India want to place it, this part, so far as 12A4 is concerned, this is all decided.
All decided. All decided.
Only thing, in the last line you place it. You have indicated that according to them, the memorandum is not applicable, not been granted to the full consideration. Finished.
Paragraph 11. I'm reading. The memorandum is not applicable to FCI and no benefit has been given to them. To the FCI.
If I am of the view ultimately that since no benefit has been given, notwithstanding the distribution, no benefit should be given, matter ends. But if I have the view that that despite the discrimination, despite the aforesaid assertion, since there is discrimination, they should get. Simple thing.
No, there are paragraph 12.
The stand is now clear.
Paragraph 12.
I did not say that if it is not being extended, it shall not be given. I did not say so. I wanted to ascertain their stand only. Stand.
Now your lordship has been pleased to. If your lordship has been pleased to decide it, paragraph up to paragraph 35 and stop there.
You've seen that.
I have seen.
Unless you say something to the contrary by showing appeal court's order. Did the appeal court has set aside that finding?
I am not saying on this.
Yes.
I am not saying on this. Your lordship, if your lordship up to paragraph 35 has said that The discrimination they are entitled to. Matter ends. But your lordship has been pleased, subsequent paragraph has been.
No, I did not say that discrimination they shall be entitled to. I did not say so. I said that I have no doubt in my mind they have been discriminated.
Discriminated.
Correct.
That part
So
is-
up to that part, finding is very clear.
Finding is very clear.
Now, next part, whether benefit they will get entitled a benefit or not, only on that part.
Only on that part. Now, only on that part, your lordship has been pleased to direct the government of India to
Correct.
come to a
So they have said that there is no extension.
No, there is no extension. Or not only that, your lordship kindly consider, your lordship's specific query was there. The office memorandum dated 1st May 1987 were applicable marked to FCI or applicable to the food transferees. Now, to that, your lordship kindly come to the paragraph 11. I am reading 3 lines. It is further submitted the office memorandum dated such and such.
Where is this constitutional bench decision of 1993 JT 173?
I shall, yes, I have with me. That
Show
only
me
I have-
that judgment.
That,
Show me.
yes, I want to show that, your lordship, only that judgment. Now, your lordship kindly come to, well, I shall show that 2 judgments, I shall finish up my
No. Very important part is whether that judgment takes into consideration the 87 scheme or not. Now, 87 scheme, if not been considered in that judgment, then even after that judgment, this scheme was introduced by them, where the central government is entitled to. It's a policy decision. It's a policy decision. Yes.
Then your lordship take decision.
No, just before going to the judgment, tell me only one thing. Does the 87 circular, is the 87 circular taken into consideration?
This memorandum?
Yes.
No, this memorandum not said so.
Then I don't show me that.
No,
Then this judgment is not relevant.
But his memorandum may say, well, so kindly consider the judgment says this what judgments I am explaining.
No, then I will not go.
This nexus is there. I'm just
No, I will not go because today the central government has, in their wisdom, brought about a new policy. They are entitled to.
Not new policy.
Yes, yes.
Not new policy. Well, what his judgment says that the food transferees are given option to opt pension scheme twice. Whether your lordship has said twice. Now they have whether the petition filed by the food transferees before the High Court, Supreme Court, that FCI food transferee, that we have been given option twice. We have not got the opportunity. Kindly give us another option so that I can go and ask for the benefit of pension.
Court did not give.
Supreme Court said, no, once you have option was
At
there,
that point of time, the Supreme Court view was that since option has been given, you have not taken, matter ends there.
Yes.
Matter ends there, correct. But this government can very well say, I will give him another option.
that is that other thing. But,
Correct. So in this case, 87, the 87 memorandum gives a further
Sir,
opportunity.
87 memorandum is not for the FCI. It is for the other central government employees. You know, which FCI is not a central government organization. You also kindly consider.
Food
So, what I'm
transferees, he has said so in paragraph number 8.
Paragraph number 8, I'm just reading. That's why I'm trying to clear you.
You cannot clarify what central government has said, Mr. Chattopadhyay. It is for the central government to clarify. How can you clarify what central government has said, excepting what is there in the affidavit?
Paragraph number 8, I'm just reading.
Yes.
I'm reading. But you also kindly consider the central government advocate, but this is the petitioner. But that's why the state food transfer is from the central government service. On their permanent transfer to FCI, paragraph number 8, I'm reading, have been given right to retain their benefit of scale of pay and leave and working fund, retirement and other terminal benefits, and pension, etc., on filing their option within cut-off date, which they were getting their erstwhile central government service by way of enactment by amendment of the FCI Act with inclusion of Section 12A 4A of the said Act. By virtue of the amended provision of Section 12A 4A of the Act, the above permanent food transfer employees from the central government FCI are getting the benefit of pension which they were enjoying in their original food transfer post. The above benefit of pension has been termed by the petitioner as liberalized pension scheme. It is further submitted that the said food transferee has already given liberty to file the above option twice, once in 1968, another in 1976, to avail such pension, and they were enjoying the food transfer such and such. Now, Supreme Court, what they have annexed.
So the answer is very clear. Food transferees were given the option to avail pensionary benefits.
Clear. But
Very clear.
another
How are you aggrieved, sir? Tell me, how are you aggrieved?
No, I am aggrieved, Your
No, no,
Lordship.
no. Tell me how will you be aggrieved? The money that they have given, you have given them, they have to refund the money. How are you aggrieved with the central government
They are
scheme?
not the food transferee. They are the second, they are the deputationists. They are not the food transferees. Then you should kindly consider what the judgment says. So judgment they have annexed, the judgment says annexure A.
I will only go through that judgment, nothing
And
more.
you should kindly go to the judgment.
Yes,
Absolutely
not
any-
judgment, is the direction.
any other thing. No, you just go to the
I don't
judgment.
enlarge everything and go on like this.
You only go to the judgment.
Yes, I've seen that one line, I've read it.
No, but there are the judgment. I shall come. But judgment, you also kindly come. The question raised.
You conclude your submissions.
I shall conclude my submission. You also kindly.
Yes, conclude it.
But the annexure A of this memorandum says the question raised in the present petition is squarely the Constitution Bench decision of this court in certain side versus Union of India in 1993 JT 173 that are not entitled to benefit of pension. Since they already exercised their option for contributed dividend fund, there is no merit in the writ petition is dismissed. What these judgments says, I have brought these judgments also. 1993 3 JT 173. I have with me what this says. But this what happens here, but this online judgment, the food transferees who are transferred in FCI, they again went to the Supreme Court and say that give us another option, another opportunity to file option. Supreme Court says once the time limit is over, there is no further option. But that is for the food transferee. There is no question for the state government deputation. Now, another thing, this judgment for 1993 3 JT, but I want to refer to your Lordship. Your Lordship, I am showing some paragraphs. If your Lordship wants to, I want to show that. But that judgment refers here. That judgment refers here.
The court did not permit this issue to be reopened once again. Only document to be disclosed. I'll confess, yes.
This judgment says, my lord.
Maybe.
This judgment says there was this person was.
I did not direct them to produce any judgment. How I directed the instruction on this. They've given an instruction. Now you cannot reopen everything.
No, you will not see the judgment.
No, no,
Just
no.
kindly see this judgment, then you
No, no, no further judgments on this. This issue is all closed.
আমার favor আছে।
এটা সবার সুপ্রিম কোর্ট থেকে এসেছে।
That's for information.
সুপ্রিম কোর্টের নোট থেকে এসেছে। আপনাদের নোট থেকে করে এসেছে। But I only refer to your Lordship, then your Lord, if your Lordship wants, if your Lordship reject my prayer, I am referring my Lord 1993, 1990.
Why will I reject it? There is no scope to accept it.
No, my Lord, kindly
No, there is
consider.
no scope to
Kindly
accept
consider.
it.
Government of India has given an affidavit. In the affidavit,
Yes, have you finished? Let me ascertain from him. I want clarification from him. You were not here, Mr. Chattopadhyay. Clarification was for him. You have preferred an appeal from the order. You have given the right. Your right is protected. I will consider it. Yes.
as you love.
Yes, sir. Kindly tell me from your affidavit now. Yes. Now you have come to paragraph, kindly come to paragraph number 8 of your affidavit report. Now you say these persons are no longer food transferees. They are permanent employees from the central government to FCI. Who are they? So they are food transferees. So you accept the fact that they are food transferees. What are you saying, sir? They are central government employees initially, yes. Language is there, whether they are food transferees or not. Yes or no? And again you need instructions. Whether these persons are food transferees or not. For that instruction is, where is that FCI?
Judgment.
Act.
FCI Act.
You place it from there. It is with me. Somewhere in the file. It is there.
Let staff regulation. With action of the platform. Opposition are letters. We transfer it.
12A.
Yes, sir. Worship can also take up, my lord, page 5 of the affidavit in opposition, which states who are food transferees, my lord, who are deputation is, my lord, it states that, my lord. Paragraph 5, page 5 of the affidavit in opposition of FCI, my lord.
Yes.
FCI.
Please.
Yes, my lord. Paragraph 5, my lord, in this connection, it's pertinent to mention here that there are 3 classes of employees with the respondent number 1. Food transferees, and that is the employees of the food department of the central government transferred to the Food Corporation of India on compulsion, having no option for being retained with the central government, and as such food transferees are getting the benefits of liberalized pension scheme of the central government as per the provisions of the Food Corporation Act 1964. The number 2, deputations from the government of West Bengal. These are my clients who had been absorbed as direct recruits, having option to be repatriated to the state of West Bengal if they found the terms for absorption with the respondent number 1 not suitable for them. The said deputation were absorbed as direct recruits and drawing the benefits of pro rata pension and commuted pension from the state of West Bengal in addition to the Sangma pension on the employee scheme 95 with contributory provident fund.
Yes.
Well, these are the 2 kinds of these.
Mr. Sinha, does the food transfer find place? This terminology, food transfer.
Food transfer terminology is there in this provident fund.
Sections.
I'll just show this one. It's here.
12A.
I'm showing you. Section. না কোন সেকশনটা আছে আপনার
সেকশন 12 এ পড়ে ওই দিচ্ছি না যদি আমাকে থাকে আমি দিয়ে দিচ্ছি
তো পড়ে দেখি লেখা আছে ফুড ট্রান্সফার মানে এখানে ফুড ট্রান্সফার দিয়ে Lordship, may kindly take this up, this provident fund accounts and allied scheme of FCA.
No, I don't want to multiply things. That's very well shown.
It mentions who are food transferees. 12 with the dekha na 12 with the dekha nahi. The staff regulations is chilo. Apna staff regulation regulation ekhuni
যেটা তুই দিতে যাচ্ছিস
না ওটা staff regulation না
but that terminology is not there in the
staff
FCA.
regulation
Well, I'm just
not there. From where was the terminology obtained? I want to know.
this has been
You had said.
No, kindly see this one. It's here, my lord. It's here. I'm not saying it. Page 1, my lord. The first page.
These are all invented by the deputationist and FCI.
This is by the provident fund and
yes, my lord. Their provident fund scheme, my lord.
Yes.
First page, my lord, chapter 1, my lord, page 1.
Yes.
Says, my lord, corporation maintains 2 types of provident fund accounts. General provident in respect of those food transfers or for the pension benefits of the government. This term is there, my lord. I'll just show the staff regulation.
FCI Act and staff regulation.
Staff regulation.
It's not in the FCI Act.
It's in the staff regulation. Transfer page.
This manual is of your.
This manual, this is
manual provident fund scheme.
But this is provident fund scheme of the FCI.
FCI.
Provident fund scheme of FCI.
There have been nomenclature is of food transfer.
Food transfers.
But in the Act it is not there, but it is there.
I'm not going
It is not so simple, sir. Anything else? What anyone wants to add?
2000 and the 2009 Supreme Court judgment clearly states I have to be treated at par with the food transferees, my lord. Anything extra given to me also has to be given to me, my lord. That's my only case, my lord. It's from that. That's it. They are giving the additional increment, but that was also given to me.
That is other thing. But that is other thing. Well, would your lordship
Judgment
kindly
clearly
consider
states.
this lordship kindly reserve for judgment. Only my prayer is 2-page note.
No, he added new things, my lord. Kindly doesn't permit that. He add new things.
No
my lord.
further
Yes,
note.
Several judgments, my lord. He meets his boss, my lord. He should not argue right now.
No. But 2-page note I don't require. But only I require. Well, I refer. I know I shall not read it.
Can you place another judgment in respect of a matter which has not been sent back on this issue?
It has been decided by the Supreme Court that
No.
that
You have to ask for review of the judgment then. I cannot sit in review over my order ordinarily.
not on that point. I'm only point is this: what they are claiming, the question of granting CPA, their right, and a right granted by an act is different. Supreme Court has said. Only I want to show that you also can reject my. I don't want to read this. I'm just referring this paragraph. You also can read the paragraph and this. Well, I'm
So one thing I will record that these central government employees option was given. Yes? That part is very clear. Ask him. Ask him also.
Well,
So the central government employees who had opted for the FCI, they had been brought to FCI and had retained with FCI, they had been given option.
Well, an option is provided in the act. You'll also kindly see the act. Option is provided in another act. That's why they do.
So they had been given option.
No, অন্য জিনিস।
ওটাই তো আসল ডকুমেন্ট, আসলটা ভুল ডকুমেন্ট। আসলটা ভুল, ওটাই আসল।
From where is he reading this?
Yeah, I'm just.
From where is he reading this?
Well, I'm just parent. This is Ministry of Pension and Rules, Rule 37, paragraph.
So I will record your submissions that the food transferees were given option.
You'll also kindly see.
That you have said so. But they were offered the option. Twice they were offered the option.
No, they.
Mr. Chattopadhyay's case falls flat. Once I record this, Mr. Chattopadhyay has argued and set up his case for so many days. I have recorded his submission. His case will fall flat. Let me show me that. Show me that.
The parent act is this.
Show me that. Show me that.
সেখানে কোথায় গেল? না এটা আরেকটা নতুনটা, যেটা অন্যটা।
না ওইটাই।
না যে আরেকটা ছিল এটা। এই যে এটা। এটা আরো
অনেকবার দেখেছি।
আরো ফেভারেবল আমার জন্য।
No, this is after this order. 2nd of February 2024.
They were going to file this, thereafter the appeal court said file an affidavit. The same thing is given here, Kindly see the reply, this copy lordship is having.
Yes.
Kindly see the reply, same thing is stated. They're already been given option 2 times. Same thing is being said.
My lord, you'll also kindly see.
I was not even given the option 1 time also. They were given 2 times. That is the case.
That is another. Your option
That is
another
case.
Well, their option. You'll also kindly see.
Why did you not disclose this in the report? Why did you not disclose this in the report? You're holding back this document. This is unfortunate, sir. You ought to have disclosed this.
I have given that.
No, you have, Mr. Chattopadhyay. Sir, you may succeed or you may not succeed. Mr. Chattopadhyay, you did not hold back documents. I know. But central government ought to have disclosed this. Ought to have disclosed this. I may be wrong in my order. That will be corrected by the appeal court. But the fact has to be disclosed to the court. This you had disclosed, but I could not take cognizance of that.
Yes, sir.
Where it has been recorded? It has been recorded by this court. No. When did you submit this?
হয়নি অ্যাপিলে চলে গেছে। হয়নি।
Mr. I will grant him opportunity to enclose this in a report. You are Mr. No, not instruction. This is. Yes, yes, it is binding naturally. And Mr. 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 Ki naam? Mr. Mukherjee, you are Mr. Shamol Mukherjee, Mr. Shamol Mukherjee. Mr. Shamol Mukherjee, Mr. Shamol Mukherjee. Yes, Mr. Shamol Mukherjee, learned advocate, represent. is concluded. This is better. Right. 2 PM fix যেটা দেখো তো 2 PM fix তো এটাই তো পুরো লড়া ছিল তো
Well, I don't know whether my learned friend has finished. Long time. Well, let us understand, well, what are the.
Well, if before Mr. Shah begins, my understanding, if I may say, Mr. Shah started his submissions when he was moving the writ, and he said that let us understand what is the change in law, and then he passed it on to me.
We had taken out
Then
an
I made
application
submissions.
also. Today can one, but today we are in the final hearing stage really.
Yes, so I
Let it
have
be
made
concluded.
my full submissions as far as the merits. My first ground was specific performance cannot be in a writ petition, and then without prejudice to that, I've shown at least about 8 or 9 decisions to say that the government, if it's in the public interest, they can come out of a contract, a written contract. That was the very broadly.
But you have not come out of that contract.
We have not. We've
Then-
suspended. We've
yes.
given them a chance to amend the
So
contract.
you have not come out of that contract.
That is the position. Thereafter, another application was made. So
That
the writ can
contention
be
of yours is still premature, if I may consider that. That whether the government can come out or not, as and when you come out of that agreement, then that issue can be considered. Today, the agreement, there is a subsisting agreement between the parties.
There is an agreement, and there was an offer given by us, which is being considered or rejected, whatever.
That is a different issue, but there is a
And it
subsisting agreement.
Came to an impasse there. So we were hoping it will be worked out, but it couldn't be worked out. So
But still then, no, even assuming it has not been worked out, no steps has been taken by you.
no, not yet.
So it's in the same position as it was. So there is a valid
The
subsisting
matter was
contract.
pending. We haven't advised them to terminate the contract yet. That after the decision we'll have to,
That is always open to you to cancel it.
but not while the matters before, because we thought it would be there. Be that as it may,
May I
Mr.
file
Shah
that?
reply to my thing, and then if required,
Well, no one required, my lord. Let my learned friend exhaust himself.
no, I'm
Because, my lord,
exhausted.
today,
But my learned
if he's
friend,
exhausted,
if
I
he
take
cites
it.
new judgments, I'll have to
Of course, my lord, I have to cite new judgments
Of
because,
course,
my
I'll
lord,
have to deal with that.
my lord,
That's
may I, my lord, answer this question? My lord, very, very simple question according to me, but it has consumed a lot of court's time, my lord, perhaps unduly. My lord, the question is, my lord, is there a contract? The answer is yes. It's an admitted position. The second question is, has the contract been terminated? Your lordship has, my lord, put the question very bluntly. My learned friend, my lord, could not, my lord, detract from the situation. The contract subsists. If the contract subsists, can you willfully not perform the contract? But if the contract subsists, then how can you say I will not perform the contract? Section 39 of the Indian Contract Act stares you in the face. A contract is, my lord, ultimately to be performed, not to be breached. If the contract is to be performed, then what is their justification in not performing it? They say that now we can get money for something that we could not have got money for before. The answer is, my lord, today, if a private party says suddenly the performance of the contract has become onerous for me, then can he resile from the contract? He cannot. My lord, for example, my lord, there are, my lord, decisions without, my lord, number. My lord, where a contract has been stated to be frustrated because, my lord, the price of the raw material has increased manifold. The court has said no. You entered into a contract with eyes wide open. There was always a contemplation that there might be a fluctuation in price of raw materials. That will not allow you to step away from the contract. And my lord, my learned friends have not stepped away from the contract. Now, my lord, my learned friends cite a change in law. But lord, today, if there's a change in law, they should have terminated the contract there and then, saying that there is a law which now makes the contract illegal
or unenforceable.
My lord, for example, my lord, today, my lord, lottery is permitted. My lord, suddenly, my lord, today, there is a law, my lord, which bans, my lord, carrying out of lottery. Or, my lord, gambling in the state of Sikkim, a permitted legal activity. Suddenly, there is a law which says it will no longer be legal. Then, my lord, you can understand you interdict the contract. You say that I cannot perform the contract because now it's contrary to law. Now, that is not the position here. So, my lord, the question is, what is the authority on which my learned friend now says, I will not perform the contract when he has not terminated it? Or when it has not become legally, my lord, impossible for him to perform, or when the law does not stipulate that you cannot perform. Well, that is the simple question. Now, my lord, my learned friends went on to, my lord, say as to how much money they can, my lord, realize, my lord, from the same raw material. Your lordship invited affidavits have come. We have shown that, in fact, my lord, they suffer a loss by not giving me the goods. But, my lord, your lordship need not go into that, because that is not, my lord, really the context in which, my lord, the writ petition has to file or considered. The simple question is, my lord, if today there is a subsisting contract, can the government unilaterally terminate it? That's number one.
No, they have not terminated.
And if they have not terminated it, how can
That
they refuse to
question,
perform?
why are you inviting the court to decide? I will not
No, my lord,
decide.
your lordship has answered that question right in the beginning. So, my lord, if the contract subsists, my lord, under what authority of law can they say I shall not perform the contract?
Yes, so you can say so.
Now, my lord, the law is very clearly settled that, my lord, today even a government cannot unilaterally, my lord, terminate a contract or alter a contract or modify a contract or vary a contract.
Yes.
My learned friend says that I am willing to give you the goods whether you pay, if you pay for it. Well, that clearly is, my lord, not the stipulation in the contract. So, my lord, that is an attempt to modify the contract which cannot be permitted. And, my lord, he says I shall perform the contract if today I am allowed to modify it. So, my lord, it is, my lord, the state's imposition that you must modify the contract if you want me to perform. My lord, that is, my lord, the long and short of the matter. And, my lord, all the judgments, all the decisions, my lord, in public policy, my lord, in public policy, my lord, this is warrant a situation where, my lord, there is a change of law.
That Mr. Ghosh has already answered. He has said that today the contract is still there. It is subsisting. They wanted to renegotiate it, but they could not succeed. But in the present scenario, they are yet to determine the contract. That is his clear finding, a clear answer to my question.
Right.
Now, kindly tell me, what reliefs are you seeking in
My
this
lord, if you
petition and to what
kindly see,
extent?
my lord, my relief is really a relief of declaration. Kindly give me a moment.
So many documents, the writ petition can't be. After the writ.
So let please have a look at
Prayer B.
My lord, prayer B is, my lord, essentially prayer B. Well, it is to perform the contract. You are, my lord, unilaterally withholding performance. Now, my lord, my learned friend says, let me understand, my lord, what is the case with which my learned friend comes to court. He says you cannot come to writ court to seek specific performance of a contract. Now, my lord, here, it is now, my lord, completely, my lord, beyond the realm of doubt that writ court can enter into matters of contract where, my lord, there is arbitrariness on the face of, my lord, so far as the actions that pertain to, my lord, statutory authorities is concerned. Now, my lord, what is the arbitrariness here, if I may ask myself the question? You issue a notice and you say, I shall not supply any free fly ash to you, notwithstanding the fact that there is a subsisting contract obliging me to do so. Now, my lord, what is the disputed question of fact that will visit this, which will make it difficult or impossible for the writ court to pass an order? My lord, there is, my lord, with the greatest respect, no disputed question of fact. At least none that has been, my lord, flagged or highlighted by my learned friends. So, my lord, the question is, my lord, not of specific performance of the contract, but, my lord, of an attempt to wrongfully and arbitrarily resile from a contract when you admit that the contract has been validly entered into and is still lawfully subsisting. So, my lord, I am not seeking specific performance. What I said is, my lord, it's really in the nature of a declaration. Although, my lord, the prayers do not, my lord, seek declaratory reliefs per se. What am I seeking?
Prayer E.
Yes, my lord, prayer E also.
But prayer E can be granted.
No, my lord, prayer E is
such time it is subsisting.
No, my lord, prayer E, my lord, is really, my lord, something that follows, my lord, prayer B.
Yes.
If your lordship grants prayer B, then prayer E follows it. So, my lord, essentially, my lord, if your lordship grants me prayer B, my lord, I am, my lord, vindicated in my stand before your lordship.
But so long the agreement is subsisting.
My lord, the agreement is subsisting. My lord, if they were to terminate the agreement tomorrow, then, my lord, I have to come up again.
Fresh cause of action.
Yes.
That is a fresh cause of
Yes, but, my lord, here kindly see something. But in the course of, my lord, the object is not to, my lord, ultimately, my lord, for the court to pass an order which will give rise to a further dispute.
Yes.
The object is to, my lord, ultimately, my lord, confine it to, my lord, the issue involved and to, my lord, finish the litigation between the parties once and for all. My lord, what are the questions?
But I cannot today today you see they tried to renegotiate it, could not succeed. Now I cannot say that they cannot determine the contract. That
No,
I
my lord.
cannot say.
I would not expect your lordship to say that. That's not my prayer. My lord, then, my lord, that would be nature of a perpetual injunction.
I cannot.
No, my lord, I am not seeking that. My lord, what am I seeking from your lordship? I am seeking from your lordship a declaration that the communications made by them, my lord, saying that I will not supply you fly ash for the reasons that they have mentioned in these communications is, my lord, bad in law. It is an arbitrary attempt on a part of a statutory authority to unilaterally breach its obligations under a contract without, my lord, any legal or valid reason.
Yes.
My lord, that is, my lord, my prayer before your lordship. Now, if consequentially, if your lordship holds that, my lord, this is not a valid ground for resigning from the performance of the contract or resigning from your obligations under the contract, then, my lord, that will amount to a declaration which will effectively prevent them from terminating the contract on those grounds. But I don't want your lordship to pass an order on those terms. But I am, my lord, inviting the court to pass an order saying that, my lord, the grounds on which they have refused to continue to supply to me fly ash, my lord, on the ground that, my lord, today there's, my lord, money to be obtained from selling these goods or not. My lord,
That is arbitrary.
That is, my lord, that is not, my lord, a valid ground for suspending supplies. Now, my lord, my learned friend uses the expression suspension of supply but not termination. So, well, if your lordship declares that this cannot be a valid ground for suspending supplies, then, my lord, whether they can thereafter on the self-same grounds proceed to terminate or not, that is something that will have to be considered. And if they
No,
do
that the court cannot go look into.
no. I completely appreciate. I completely appreciate.
Yes.
So, my lord, the first question which I have to answer to your lordship, my lord, is this, my lord, really, my lord, something that seeks specific performance of a contract? Now, my lord, may I, before I go into the judgments that my learned friend has cited, my lord, just tell your lordship this. My lord, today, specific performance of a contract is, my lord, when a contract has been breached. Now, my lord, my learned friends have admittedly breached the contract.
Yes.
Now, my lord, they are not saying that, my lord, I am in breach. They are saying that whatever I have done lawfully. Now, my lord, the question that therefore must follow is, my lord, whether the refusal to supply on the grounds on which my learned friends have refused to supply is lawful or valid. Now, my lord, so far as that is concerned, my lord, ultimately, if your lordships declare that it is not lawful or valid, whether still they will be supplying or not, my lord, is a different matter. Now, my lord, I am seeking, my lord, unilateral.
Will the court pass an order which cannot be enforced?
No, my lord, there's no question of not enforcing it. My lord, my learned friends are today, my lord, in breach of an obligation. I say that. They are saying that no, they are not in breach of an obligation. And, my lord, they are saying that they are lawfully and legally justified in withholding supplies because of ABCD reasons. Your lordship is simply looking at the reasons and, my lord, declaring, that is why I started with, my lord, the prayer of declaration, that no, these are not valid reasons which will entitle you to withhold supplies. My lord, if they still do not supply, then of course my recourse will be, my lord, separate. But, my lord, today, if they do not supply, in spite of your lordship's, my lord, order saying that no, these are not valid reasons which will allow you to step away from the contract, arbitrarily resile from the contract, unilaterally seek to modify the contract, then, my lord, after that, what cause of action I have before a civil court or a civil forum, I shall, my lord, decide.
No, this part I want to understand, clarify. The relief that this court will grant, will it not be complete?
Yes, according to me, it will be complete, my lord, because today when your lordship declares rights, my lord, either by granting prayer B or otherwise, then, my lord, that declaration is complete in itself. My lord, what is the dispute? The dispute is whether, by reason of the fact that there is now money to be obtained from the sale of fly ash, they are still obliged to give me, my lord, fly ash free of charge for the duration of the contract.
No, up to a particular limit and thereafter.
That's right. For fly ash, my lord, free of cost up to that particular limit,
and thereafter at the rate that is 1,000 metric tons perhaps. 1,000 metric tons perhaps.
Well, there are administrative charges of 6 rupees to be paid. That is all.
So whatever.
Well, that is, my lord, the question. Well, lord, so the obligation is to, my lord, give me fly ash at the determined rates.
Assuming I grant prayer,
B.
I want to understand this part. Assuming this court grants prayer B.
Yes.
You said that even if you are seeking for a declaration, in fact, that the grounds on which they are withholding the supply is arbitrary, and therefore such grounds cannot be construed as valid grounds for suspension of supply.
Right.
That you're insisting the court to grant. Now, assuming the court grants this relief,
Yes.
will you be entitled to the supply?
Yes.
Till then, if they do not supply, will the court be entitled to enforce that order?
Well,
That is another important aspect.
Well, may I answer that question?
Or will you be required to go to the civil court to enforce it?
Well, may I answer the question?
Yes.
Well, your lordship's aware, lordship is aware that apart from the writs of mandamus, certiorari, quo warranto, and habeas corpus that we are conscious of, we also, in the course of filing writs, seek declarations.
Yes.
Now, today, if we seek declaration, that declares, the legal position. Our rights and obligations are decided by, the writ of declaration.
But you are therefore having regard to the judgment cited by Mr. Ghosh, not seeking for prayer B, you are only seeking for declaration to this extent.
I am, kindly allow me to, come to.
No, I'm trying to understand, Mr.
No.
Only this much.
No, it's right. Now, today, effectively, if your lordship reads down prayer B, what is, the content of prayer B? Kindly, read it, in a more meaningful manner. Well, it is not very usual to seek declaration in writs, but it is not unusual also. Now, today, what am I seeking in prayer B? Quashing of the letters and directing them to supply in terms of the conditions of the contract dated 1st January 2019. So ultimately, my lord, I am seeking a declaration that the grounds on which you have stopped supplies or you have refused to supply are not good grounds. Well, that is what your lordship will be declaring if your lordship passes prayer B, an order in terms of prayer.
Prayer B will include specific performance also.
Well, kindly see, my lord, here specific performance is not something that's an anathema to my lord writ courts.
No, not that. Well, I am not on that.
Yes.
If you insist that this court only grants the declaration.
No, my lord, kindly see, my lord, declaration must precede the grant of any other relief. Well, let me put it that way.
Yes.
Now, my lord, once your lordship declares that, the next step that must automatically follow is therefore, if there is no reasonable basis for you to withhold supplies, then you must give supply. So, my lord, the direction there, my lord, then, my lord, the writ of mandamus comes in. The mandamus to perform, my lord, what? A duty, my lord, to act, my lord, in terms of a contract and not to unilaterally, my lord, step away from the contract or modify or vary or alter. Because, my lord, my learned friends have said expressly, my lord, in the course of submissions, and, my lord, also in their affidavit, that ultimately they wanted me to, my lord, enter into a modified contract and agree to pay them the price of, my lord, these goods. So, my lord, here today, once your lordship, my lord, I am breaking it up in two parts. My lord, my first case is our case of declaration. If your lordship declares that, my lord, the grounds of suspension are bad, then, my lord, today, my learned friends must ultimately follow up and perform the contract. Because the only reason that they say they are not, my lord, obliged to perform the contract is because of the alteration in circumstances which they have, my lord, now manifested in the letters which are of 19th July, which is of 19th July 2022.
Yes.
Now, my lord, will please have a look at 19th July.
Their letter.
My lord, 184, my lord, annexure P39. Please have a look at, my lord, what this letter says. First, please come to 186 straight away.
We therefore call upon you.
That's right. We therefore call upon you to agree with immediate. But before that, my lord, they say as to why, my lord, they will not perform the contract as it stands. My lord, 2.5 pages of, my lord, content to say as to why, my lord, they have no obligation to perform the contract as it stands. But, my lord, as your lordship has pointed out, they do not terminate the contract. Instead, they say, we hereby call upon you with immediate effect to proposal to enter into a fresh agreement. So, my lord, what are they seeking? They are seeking to, my lord, jettison the present agreement unilaterally. They are, my lord, calling upon me to, my lord, modify the terms of the present agreement by entering into a fresh agreement, my lord, which cannot be done. My lord, there is ample authority which I am carrying. But the authorities say clearly that, my lord, even in government contracts, even statutory authorities cannot unilaterally, my lord, seek to resile from a contract or modify a contract. Well, essentially, well, if your lordship looks at this last paragraph at 186, this is what they're saying. Now, my lord, let us understand, my lord, today legally how my learned friend is justified in this stand. He has said, my lord, I have not terminated the contract. Now, my lord, he did not terminate the contract even before the writ was filed. He was at liberty to do so. Instead, he calls upon me to modify the agreement, and he says, well, in very specific terms, by this letter, even at page 184, that, my lord, unless you modify it, I will not perform it. The question is, my lord, whether this answers, my lord, the question of arbitrariness, which means essentially that, my lord, a government agency or a government corporation may enter into a contract and then they say that I will not perform the contract unless you agree to modified terms. The question is, my lord, whether this violates Article 14 or not.
Yes.
Well, Article 14, in my respectful submission, would include within its scope an attempt to unilaterally and arbitrarily enforce on, my lord, a citizen who may be a contracting party, my lord, terms of a contract which, my lord, were not agreed upon between them. And in the process, my lord, unilaterally seek to resile from obligations under a contract, and, my lord, unilaterally seek to modify the terms of the contract, all of which are not permitted. They have all, my lord, ultimately fallen foul of Article 14. And, my lord, this is really the only question. Now, my lord, my learned friend has really canvassed 2 points before your lordship. One is specific performance. The court can't grant specific performance. I don't think, my lord, today, my lord, your lordship is being asked to go into, my lord, a disputed, my lord, question of, my lord, facts, which, my lord, will have to weigh the balance as to which party has performed or not performed its obligation, and therefore, my lord, whether a party is rightfully entitled to resile. Here, my lord, the question is a very confined question. And he does not say that you have failed to perform any obligation. He simply says that I now find it no longer profitable to perform this contract with you. So, my lord, there is no disputed question that needs, my lord, consideration. And there is no weighing of, my lord, reciprocal obligations which the parties have failed to perform vis-a-vis each other, as to whether, my lord, to consider as to whether now he should be directed to perform the contract. The only question is, if today you have entered into a contract, can you enforce, can you say that I will not perform the contract unless you modify it? Can you force a party? Can you force a party by reason of your, my lord, position as, my lord, the principal contracting party to amend or alter the contract and threaten the party with non-performance unless he agrees to your terms? The question is whether this will, my lord, ultimately be something that will be arbitrary.
Yes.
Now, my lord, so far as this is concerned, may I, my lord, straight away first, my lord, come to my learned friend's cases. Well, kindly see, my lord, the first decision subject to correction which he relied on was 1987, Volume 1, Supreme Court Cases 658. Right?
Settle down.
Well, this is a
Judgments gulo আছে। ওই যে পুরো।
কোনটা করেছে বলো? 2014 14 SCC 102. Okay, ঠিক আছে, ওইটাই দেখাই। Well, I'm told that the first decision cited was 2014, Volume 14, Supreme Court Cases.
Paragraph 58 and 60. Is it a church? Paragraph 58 and 60 referred.
Yes, my lord, 58 and 60. Well, let me, my lord, read these paragraphs and show to your lordship as to how, my lord, completely, my lord, inapplicable this decision is, my lord, from the facts of the case. In the ultimate analysis, the whole controversy boils down to a breach of contract by MP-RTC entered into with the appellant. The scope of judicial review is very limited in contractual matters, even where one of the contracting parties is the state or an instrumentality, parameters of within which power of judicial review can be exercised. Then, my lord, reference is made to Tata Cellular. And, my lord, so far as 60 is concerned, in our opinion, the case put forward by the appellant would not be covered by the aforesaid ratio of law laid down by this court. The High Court, in our opinion, has rightly observed that the appellant can seek the appropriate relief by way of civil suit. High Court, in exercise of its jurisdiction under Article 226 of the Constitution, would not normally grant relief of specific performance of a contract. And then my lord, reference is made to Ramchandra Murarilal Bhattad, that this court would not enforce specific performance of a contract where damages would be adequate remedy. Also held that the conduct of the parties would also play an important role. Expansive role of the courts in exercising its power of judicial review is not in dispute, but as indicated here above, each case must be decided on its own facts. Let's, my lord, concentrate on the facts of this case. My lord, specific performance of a contract, my lord, when today there is an attempt to arbitrarily interdict the contract. I am, my lord, saying that you cannot interdict the contract, you're obliged to perform the contract. My learned friends have said, I will not perform the contract as it is. I will perform the contract only if you modify it in line as I suggest. So, my lord, it is ultimately an attempt of one party who holds the superior bargaining position to impose its will on another party having an inferior bargaining position, despite having entered into a concluded contract with the other party. Now, my lord, so far as the, my lord, question of law is, next question, next judgment. Okay, proposition that good. Then, my lord, my learned friends relied on 2022 15 Supreme Court cases, 536. My lord, please see, my lord, 2022 SCC online SC 247. My lord, paragraph 2 is important.
Yes.
My lord, please have a look at paragraph 2 first, my lord. Appellant Municipal Council is running educational institution schools. There was a requirement for benches, almirahs, and tables in a school run by it. Accordingly, resolution dated such and such came to be passed for purchasing desks, benches, almirahs, and tables. E-tender was issued by the appellant with a letter dated such and such by virtue of which bids were invited. That original writ petitioner number 1 participated in tender was declared successful. Thereafter, an agreement came to be executed between the original writ petitioner and the appellant, as a result of which work order number such and such came to be issued. However, in view of COVID-19 pandemic and lockdown enforced, Government of Maharashtra published a notification by which it was provided that owing to COVID-19 restrictions impacting government finances, non-priority expenditure like the present case should not be incurred. In pursuance of the government notification, President of Municipal Council such and such informed the chief officer, as the municipal council was not having any income due to ongoing lockdown and most of the schools were closed due to pandemic, no purchases should be made and no proposal for the same should be forwarded. In view of the above, the chief officer of the municipal council informed the original writ petitioner the work order had been suspended until further orders. It is the case on behalf of the appellant that after obtaining the report of education officer that the original writ petition number 1 had not taken any further steps with regard to supply. Now, my lordship will kindly see, my lord, the last sentence of, my lord, this paragraph. My lord, impugned judgment on order the High Court has set aside the action of the municipal council and has held that the original writ petition is entitled to make supply in pursuance of the work order dated such and such. Now, my lord, kindly have a look at paragraph 5. Sri such and such has submitted pursuant to orders passed by this court. The official council visited the premises on such and such. The official of the council were asked to visit Nagpur, which they did. On inspection of the goods, it was seen that the goods do not meet the requirement of the work order and that they were not prepared for the council as claimed by the original writ petitioners before court. It is pointed out even with a communication dated such and such, respondent number 1 had admitted that the goods were not available. It is therefore submitted there are no manufactured goods available as per specifications. And then, my lord, will kindly have a look at paragraph 8. It is in the background of these facts that your lordship will consider paragraph 8. At the outset, it is required to be noted that by the impugned judgment in order, the High Court has issued a writ of mandamus virtually granting the relief of specific performance of the contract work order. From the impugned judgment on order passed by the High Court, it appears that the High Court was made to believe that the original writ petitioners had already manufactured the goods which are customized and as per the specification of the work order. However, it is now found that there are no manufactured goods readily available which can be supplied to the appellant counsel. There are disputed questions of fact, such as whether in fact goods were manufactured as per specifications or not. Nothing on record before the High Court that goods were in fact actually manufactured by the original writ petitioner as per specifications and the requirement of the counsel as per the work order. In the absence of any evidence and material on record, and there being disputed questions of fact, the High Court ought not to have passed the impugned judgment on. My lord, kindly see. My lord, here, my lord, there is an assertion made. There is a inquiry. It is found that the assertion is incorrect. Therefore, my lord, the court says that yes, these are questions which will have to be gone into in trial. At paper ki dekhi. 249.
That was the municipal council of.
Municipal council.
Yes.
The part I relied on.
Paragraph 8.
Yes, just even otherwise no writ of. That's the part I
That's
relied.
part. Yes, I marked it.
Not, doesn't
Even otherwise, no writ of mandamus. Yes.
that was part.
My lord, the question is, my lord, here, my lord, I shall be citing before your lordship, my lord, the judgment which says,
Your portions have been marked. I was not disturbing Mr. Shah on this.
No, that's what I just.
He indicated the factual basis for the judgment. He has a right to show.
well, naturally, my lord, every
Yes,
judgment
yes,
is, my
yes,
lord,
yes.
a case for the proposition, my lord, that it ultimately lays down factually. Now, my lord, so far as these judgments are concerned,
Mr. Ghosh was taken aback whether this line actually existed in the judgment or not.
I
What
was
do you
thinking that was. I had said even otherwise specific.
Yes,
clause,
yes,
but
yes.
that part
my lord,
was not
the
placed.
question is, my lord, whether, my lord, it is an absolute proposition. First question. My lord, does my learned friend now, my lord, propose to say, after, my lord, the law has received, my lord, so many interpretations that, my lord, the writ court cannot enter into the contractual arena at all? I would, my lord, dare say that, my lord, that law is now, my lord, in the trash bin. Today, the writ courts have said, if we find arbitrariness, if we find, my lord, wrongful dealings, if we find, my lord, unilateral exercise of power, we shall interfere. Provided, of course, ultimately the factual scenario is such that, my lord, the writ court cannot, my lord, within, my lord, the four corners of its jurisdiction, enter into, my lord, that domain of inquiry into such facts.
Yes.
The next, my lord, judgment, my lord, 2022, 536, ঠিক আছে. 536 is the original, ঠিক আছে. Paragraph গুলো বলো. Well, our next judgment is, my lord, Surjit Singh Sahni versus State of Uttar Pradesh. This is, my lord, 2022, volume 15, Supreme Court cases 536.
Yes.
My lord, paragraph 6 is, my lord, paragraph 6 and 9 are relevant. I don't know, my lord, it may be still marked in your lordship's
Yes,
copy.
yes.
It's marked. My lord. High Court, by passing order dated such and such, as did not realize and or appreciated that the writ petition itself was required to be dismissed on the ground of delay laches, and the same was filed after 11 years from the date of execution of the sale deed, under which the right was claimed. We have come across a number of such orders passed by the High Court directing authorities to decide representation, though representations are made belatedly, and thereafter when a decision is taken on such representation, thereafter it can be said that on behalf of the petitioner that the fresh cause of action has arisen, such and such. Then, well, paragraph 9. Even otherwise, on merits also, we are in complete agreement with the view taken by the High Court. The High Court has rightly refused to grant any relief, which as such was in the form of specific performance of contract. No writ under Article 226 of the Constitution of India shall be maintainable and or entertainable
This is
for
paragraph 6, what Mr. Ghosh has said.
Yes. Well, my lord, paragraph 9, my lord, is what is ultimately the summation of the judgment. Even otherwise, on merits also, we are in
No,
complete
this is
agreement.
actually paragraph 6.
Yes.
What 9 you are reading is actually paragraph 6 here.
Oh, I see. I see.
You are reading from SCC online, no?
Well, I am reading from SCC online. I don't know, my lord, why the paragraphs are not tallying.
Strange. Paragraphs are not tallying.
Well, lord, paragraph 6, my lord, in
starts
by...
with the words, even otherwise on merits also, comma.
Well, this is paragraph 9, my lord, in
Yes.
my copy. But anyway,
It's same judgment, as long as same judgment.
same judgment. Same judgment. My lord, kindly see here, my lord, the question was delay and laches. Well, that ultimately compelled the court not to go into the question. You say, my lord, we have learnt, my lord, from our very initial days in the profession that when you come to the writ court, you come to the writ court panting. You can't, my lord, sleep over your rights and then suddenly wake up and say that, no, I will file a constitutional challenge, well, to an action after having, well, slept over my rights for significant periods of time.
Yes.
Well, the next judgment was 1979, two Supreme Court cases, 4-9. This is Motilal Padampat. Well, this is, my lord, the classic case of, my lord, promissory estoppel.
He placed paragraph 24.
Yes. Well, this judgment, my lord, we have always cited on, my lord, the doctrine of promissory estoppel. But, my lord, what my learned friend now seeks to rely on is paragraph 14 of the judgment. 24 of the judgment.
Yes. He placed a mere claim of change of policy would not be sufficient to exonerate the government from liability. The government would have to show precisely is the change policy that is the reason and justification so that the court can judge for itself what with the public interest lies. In middle of this paragraph.
This is, my lord, the case for public policy.
And yes, promissory estoppel is on the top.
Yes.
Now, well, points were there only.
Well,
he also stressed on this public policy also.
Well, public policy, my lord, ultimately must reflect in, my lord, a change of law, which makes the contract illegal. My lord, you cannot say that, yes, it is contrary to public policy, but I'll let the contract subsist. You cannot say that the law does not render the performance of the contract illegal, but I will not perform the contract. My lord, public policy is something that must ultimately manifest. For example, my lord, why would the question of public policy discussed here? Ultimately, so far as this is concerned, there was no concluded contract. There was a promise made. There was a representation made on which the party acted. The law of promissory estoppel said that today, if you have on my promise, altered your position to your detriment, I should now be allowed to resile from the promise. And there, my lord, in the absence of a concluded contract, the courts have held that no, when you have induced a person by your representations, promises or actions, then, my lord, notwithstanding the fact that you have not entered into a contract, binding contract, you will not be allowed to resile from that. But the exception to the rule has been and always has been that, my lord, public policy warrants it. And, my lord, there the saving grace is, my lord, there is no concluded contract, which will therefore require determination. And as your lordship has seen in this case, my lord, there is no determined contract. They do not say that I will not be able to perform the contract even if I want to because it has now become illegal. So, my lord, public policy may come to the rescue in cases, my lord, where there are no concluded contracts, where, my lord, there's a promise made, or, my lord, where there's a legitimate expectation which is born out of the promise, but, my lord, not where there are concluded contracts. Then, my lord, that would be affording the, my lord, state authority or the state party and, my lord, an opportunity of, my lord, ultimately breaching a contract whenever it says that it is now onerous for me to perform it, which is not available under section 56 because, my lord, section 56 of the contract talks of frustration, impossibility of performance. This is not a case of impossibility of performance. My lord, just see paragraph 24, my lord, one part which, my lord, which my learned friend relied on. Well, I'll just read this portion, my lord. If your lordship sees, my lord, the SCC online version at page 43.
Line starting with?
Well, lord, it is about, my lord, the middle of page 43. It starts with the words mere claim of change of policy.
Yes, that's what I...
Yes. Mere claim of change of policy would not be sufficient to exonerate the government.
That is the line.
What precisely is the change policy and also its reason and justification so that the court can judge?
That's the line, yes.
And well, there is no concluded contract here. That is, well, the distinguishing feature. That's it. 188. Well, the next decision is Sharma Transport 2002, Volume 2, Supreme Court cases, page 188. Well, the paragraphs relied upon were paragraphs 23 and 24, I'm instructed.
Which judgment?
Yes.
Which judgment?
Well, this is 2022.
Yes, 2020.
Sorry, 2002 2 SCC 188. Well, this is my lord relying on Motilal Padampat.
This is also paragraph 24.
23. Well, this again, my lord, ultimately discusses promissory estoppel.
Yes, then 24 he places also.
Yes, my lord. It is equally settled law that promissory estoppel cannot be used to compel the government or a public authority to carry out a representative promise which is prohibited by law, which was devoid of the authority or power. Now, my lord, may I just pause here for a moment? Which is prohibited by law. So, my lord, it must be legally prohibited, or which was devoid of authority or power. So, my lord, it was initially, my lord, a promise made without the authority to make such promise. And hence, my lord, today, if it is illegal and if the promise is made without authority to start with, you cannot be compelled to perform the promise. Again, my lord, no question of a concluded contract. That your lordship will find, my lord, from paragraph 23.
Yes.
Well, now, of course, my lord, in the Brahmaputra Metallics case, Supreme Court has, my lord, said that promissory estoppel will apply both to, my lord, contracts and to, my lord, promises made, which means that, my lord, today, Brahmaputra Metallics, which I shall be showing your lordship, has clearly said that even if you have entered into a contract, you cannot resile from that contract. Because, my lord, when you enter into a contract, a party, my lord, ultimately, my lord, is, my lord, committing himself to, my lord, a certain state of affairs. For example, here, my lord, the obligation is to lift a certain quantity of fly ash, whether, my lord, he finds a buyer for it in the market or does not find it, which will, my lord, naturally entail incurring of lifting costs, shifting costs, storage costs, etc. But, my lord, I shall come to my decisions, my lord, later. My lord, here, my lord, your lordship will find paragraph 23, my lord, ultimately says towards the end of the paragraph, quoting, my lord, Motilal Padampat Sugar Mills, it's the last few lines of, my lord, page 202.
Yes.
Therefore, the government cannot claim any immunity from the doctrine of promissory estoppel and cannot say it is under no obligation to act in a manner that is fair and just, or that it is not bound by considerations of honesty and good faith. In fact, the government should be held to high standards of rectangular rectitude while dealing with citizens.
And line thereafter, in order to
Since the
resist its liability, the government must would disclose to the court various events insisting its claim to be exempt from liability and would be for the court to decide whether those events are such as to render it inequitable to enforce the liability against the government.
That's right, my lord. How now, my lord, so far as this is concerned, my lord, it is again something, my lord, that ultimately transcends into section 20 plus paragraph 24, but it will be, my lord, inequitable, my lord, when today ultimately there is no contract. So, my lord, I am not tied down or fettered to a contract. So, my lord, I can resile it because I don't have any concluded contract, and public policy demands that I revisit, my lord, the promise that I had made earlier. That's number one. That's Anglo-Afghan agencies, my lord, the decision, my lord, which started the ball rolling for promissory estoppel cases. And, my lord, secondly, that you did not have the authority to enter into the promise in the first case. Thirdly, it has now become illegal. Well, the next case is, my lord, 1998, one Supreme Court cases 572.
He relied on para 21.
Yes, but before that, your lordship will kindly see, my lord, here, if your lordship will kindly see paragraph 2 once. It was contended on behalf of the writ petitioner that it had applied for a license for setting up an industry at Betnoti in the district of Mayurbhanj and obtained a provisional registration certificate. Permanent registration certificate as a small-scale industrial unit was granted by the Director of Industries on such and such. Industrial unit also obtained a production certificate certifying that it had started production. Certificate of registration was renewed from time to time Clause 8 of IPR effective from the period provided that the village cottage industries certified and such shall be exempt from purchase or sales tax for 5 years on construction material, raw material, machinery and packaging materials. Small-scale industrial units in non-backward areas would be entitled to this exemption only for 4 years. The case of the writ petitioner before the High Court was that it set up its industry in the district of Mayurbhanj pursuant to this IPR. It had obtained a huge loan from the United Bank of India in terms of the IPR. It was entitled to tax exemption on purchase of groundnut, mustard seeds, etc., which were used as raw materials. Then, well, so far as these is concerned, exemptions were granted up to a period of time. Then paragraph 6. The High Court allowed the writ petition on the ground that in IPR a clear and unequivocal promise had been made by which a legal relationship was sought to be created. Well, that was the basis on which it was allowed. Then, well, so far as 9 is concerned, in our view, this appeal cannot be shut out on the preliminary ground that no appeal was preferred against 2 earlier decisions. Then, well, again, reference is made to a large number of cases. Then, if you kindly have a look at paragraph 21. Well, for example, paragraph 19, if your lordship sees, in the case of Kasinka trading, notification issued by the Customs Department in public interest exempting certain goods from basic import duty, and then notification was issued withdrawing exemption. Challenge was made to the withdrawal of the notification by some importers who claimed that they had entered into agreements on the basis of earlier notifications. It was held by this court that the government had issued the first notification in public interest for a certain period. It was felt later that in public interest, exemption should not be continued even though that period had not expired. Well, there is no question of public interest here. It is of the state now wanting to result from a contract to earn what according to the state is greater profits. Of course, we have shown that in fact the state is taking upon itself an additional massive financial burden of clearing the stocks, which is otherwise not willing to give away to. And again, public interest must override. But what is the question of public interest?
Another 5 minutes thereafter on another date, because I have original site.
Very well, my lord. I said,
but Mr. Shah, now that you concluded on the next date.
Yes, my lord.
Another 5 minutes you have. You proceed. Because
I will do something, my lord.
Yes,
what I'll do is, my lord, so far as these decisions.
So you show, and I'll give you 1 more hour. So I think you'll half an hour will do, or at the most an hour.
Well, I don't need very much time, my lord, because my case is on a very narrow conspectus. My lord, kindly forget all the other applications that have been filed.
No, you just distinguish the judgments that you do.
My lord, that I'll do. That I'll do. My lord, so far as this is concerned, my lord, your lordship will see that when we are talking about public interest, this is the basis. Then, my lord, please see paragraph 25 since your lordship is looking at this.
Yes.
Moreover, as it has been noted earlier, that the IPR itself has not been granted. Moreover, as it has been noted earlier, the IPR itself had not granted an exemption, but had indicated that orders will be issued by various departments for granting exemptions. The exemption under the sales tax could only be issued under Section 6, which could be amended or withdrawn altogether. This is expressly provided by Section 6. If the respondent acted on the basis of a notification issued under Section 6, it should have known that such notification was liable to be amended or rescinded at any point of time, if the government felt it was necessary to do so in public. Well, this is the distinguishing feature. So you rely on a provision, which is not an absolute right, but which says that it can be revised at any point of time.
Now, they are also entitled within their rights to determine the contract. As and when they determine that issue will come up, this is a case of exemption being withdrawn. And here the exemption was, here the contract is still subsisting.
Right. But when my learned friend relies on this judgment, ultimately, what is the distinguishing feature of this judgment? Here, the promise was based on the basis of a section, which itself provided it can be withdrawn at any time or modified at any time. That is, the distinguishing feature of this judgment. I can, come back on the next date. What I'll do, for your lordship's, convenience, is I shall, instead of going through all the judgments, give your lordship my own.
No, just one. How many are there? 1, 2, 3, 4. No, 5 more judgments are there.
I'll distinguish.
So 5 more judgments, you kindly distinguish them, and then it will be over. If you want to address me on that,
kindly give me 1 hour. I shall finish.
Yes. Hey, what
is this? My lord, can one, there's a reply, may I just
Today it could have been possible, but there is a 3:30. That's a difficulty. Can 1 is there. What do you want to
My
find?
lord, can one, my lord, there's a reply. I shall not rely on the cans since your lordship is hearing the main writ now. Just keep it on record.
Affidavit in opposition and the affidavit in reply filed on behalf of the petitioner and the respondents. Take it on record. In the can 1, can 1. Main application heard Mr. Shahal and a senior advocate representing the petitioner. Is this matter for further consideration on the same heading on? Bolo, bolo, bolo. Ajay. Shukurbar.
Not sure. No, I don't think so.
Friday?
Yes, next Friday. My lord, if your lordships can take it up at 2 o'clock like today, my lord, it will be complete. I'll finish in an hour's time. That is my commitment to court.
I also think Sheshaya ভালো এটা অনেকদিন পরে আছে হ্যাঁ two.
Opposition and reply.
এই আরেকটা মামলা আছে ডাকুন মিস্টার মজুমদারের চট করে ডাকুন 3টে বাজিনি ডাকো হ্যাঁ পাঠানটা আছে তো একটা
ভালো করে গুছিয়ে
এই পাঠানটা হয়ে গেছে এটা ও আগে ছিল তাহলে অরিজিনাল সেট করে দাও অরিজিনাল সেট জি আমি হেডিং এই থাক দুটোর সময় নেবো শেষ করে দেবো হেডিং করে লাভ নেই Yes. Original side.
Grateful.
No, you have come very well. Then you conclude it. Wait, let me call down. Let it be called on. Let it be called on. Dako. Yes. You don't want to do it. I could not hear you. Sorry.
Well, by today, whether it will be completed,
That is a different issue, sir. Because you see, these matters are pending. I thought
can it be fixed any, except Friday any day, but 2 o'clock or 3 o'clock? Both of us can finish one day.
No, these are assigned matters. I take up on this date.
My lord can fix this day, any date, my lord. Except Friday, any date. For both
You
of
don't
us.
want to do it today. Then there are other matters. People are waiting. I'll take it up immediately.
No, I can do it, but I will not be able to finish it. That's all.
Continue, sir. I'm not stopping you to argue, but I'm only indicating I had heard this matter previously. Now, if you want to conclude it, you conclude it. Otherwise, you don't conclude it. No, I'm not saying you conclude it within 10 minutes, 20 minutes. I did not say so. But if you want to conclude it, do it. Otherwise, I'll hear some other matter. This will continue. That's why I asked him whether he wants to do it or not. He wants to do it. Very well, continue. Yes. Mr. Sen, next date. It is there, next date. Because this matter was also pending for quite some time. So, yes, next date. I don't think any other matter would be possible, so it will continue. Any urgent matters? Because these are assigned matters, so can't be urgent. Mention on Monday. Mention on Monday. If you have urgency, mention on Monday. Mention, no, the matters are in line. How can I give preference? These are assigned matters. These will be taken up in order. If you have any urgency, mention on Monday. I can, if I find out, I can accommodate you, I'll accommodate you. Yes, Mr. Sinha. Yes, yeah, 3:30 is there. This matter will continue unnecessarily. Everyone will be stuck here.
And only one thing, but item numbers 10, 11, 12.
Item numbers?
10, 11, and 12.
Yes.
10, 11, 12, 13. 10, 11, 12. These are applications for leave to proceed before the against
On the next occasion, I'll fix them first and thereafter I'll take up the
very
assignment.
short matter because
Yes,
the
I'll
opening
fix
is-
them first and take up.
Great.
But assigned matters will be taken up in order. All of them in order. Yes, Mr. Mojindar, you don't have to run. Mr. Sinha will conclude. Don't have. He says that he will continue.
No, that was a different.
No, he says that he wants. Yesterday, I told you that it may not be taken up today, but he says that he wants to continue.
Not that one. Actually, I am thinking if one day.
That is why I fixed other matters also. It appears that
If he continues.
yeah, I'll be not continue for 10 minutes. Beyond that, I'll not take up. Today is 3:30. I'll not come ready on the next occasion. Continue for 10 minutes today. No, I'm saying.
May I tell one difficulty?
Yes, yes.
Friday, every court content matter is fixed after 2 o'clock. There is a problem, my lord.
But Mr.
So
Sinha,
today I am free. There is no content.
Is SBI on repeated
Mr. Sinha,
contempt?
Mr. Sinha, difficulties that these are assigned matters. Now, you've seen my list. I'm having the other group is also there. Original side
No, I'm
not
ready,
getting
my lord.
adequate time. I have to take up original side matters on the other days. If I take up these assigned matters on those days, it will be very difficult. I'll accommodate you if you are not there, but still then I'll come. Continue for 10 minutes up to 3:15.
Then, my lord, can I, last order, my lord told me, you show me the authority of board resolutions. Let me touch, my lord, the prayer is, their challenge is in respect of the circular, did it? It's not.
What are the facts? The facts are that they are employees. Your employees. They did not upgrade themselves by appearing in the examination. They did not upgrade themselves by appearing in the examination. The question for consideration before this court is whether the failure on the part to upgrade can invite consequences of this nature. That is the only issue.
They are getting, what they are getting? Getting incentives. 5 incentives are given to them. This is not a part of a salary.
How can you withhold incentive for someone and allow it to others?
No, allows not to others. These
Yes,
are
you are giving to suspended employees.
no suspended employee. Suspended cannot get it because they are not entitled to use the computers. They cannot appear for exam. That is the reason. And that is the on defer. That is, I'm showing it well. Why they are not allowed? They have no access to the Active Directory system to appear in the exam. So they are getting the advantage by default. But the next year we have corrected it. Something that to get clinching materials, they're staying in the house, so the house to be maintained. Phone there to get it. Servant house there to get it. But other things.
Pardon.
There are 5
Slowly.
conveyance. There is one is conveyance.
Yes.
Second is clinching materials. Third is newspapers. There are 5 things. So the first time when the circular issued, my lord, by default they have been exempted. For the reason because they don't have Active Directory system access. They cannot use the computer.
So you are saying incorrectly they had been exempted.
Because they cannot.
So have you recovered from them?
Why shall I recover, my lord?
Why?
No. When they're suspended, from that year, they will not get it. From that year, they will get it. Unless they complete, for the first year, this was circular. Because they had they did not have an access to the Active Directory system. So they cannot complete the course. But the next year, bank thought it, that at least they're staying in the bank's house. So they have to maintain the bank's house. So they have to get the clinching materials. So 2-3 things, it was said that you will not get it, these things you will not get it. For the next year, they are not getting out of 5, 3 things are not getting. Next year circular.
Magazine, that is paper. Conveyance,
they will not get it.
cost, conveyance expenses, magazine cost, and cleansing material.
Clinching materials. Clinching materials, they will get.
Cleansing material. Cleansing material, correct. Depending upon the grade scale. So they are not getting that.
No, they are getting clinching materials for the next year. For the first year, we have straightway said that the suspended employee will not get it. For 3 months only, January, February, March. Throughout the year, they are getting. So therefore, by default, because they cannot complete the examination system because they don't have access to the Active Directory system. That is why they are not getting. They cannot appear the exam. That is why the next year we thought of it. Why they will get? We have stopped give them everything, but we stopped it. Some things they will not get, some things they will get, which are essential. That is clinching materials, servant allowance, and paper.
What has conveyance to do with the training, with the examination? What has conveyance to do?
What else?
What has conveyance to do with this?
State Bank of India has 1 lakh employees.
Page 6, paragraph 5E. That is the stand of the bank. Page 6 of their opposition.
Of theirs.
Page 6, paragraph 5, subparagraph E.
Apart from that, my lord.
It's opposition. ঠিক আছে. Yes.
6.
Very well. A person cannot claim it as a matter of right. Fair enough.
The purpose is this.
The purpose is this, my lord, but the suspended employee cannot do any work. That's why they were debarred. They were allowed to take it because they cannot complete the examinations. They cannot appear the examinations because they have no access to the system. So that is why they are excluded. But next year, bank thought it that something should not be allowed to them. So 3 items were not allowed for the next year. That is not the issue. Let me come to the main issue. Whether bank can do it, my lord, whether bank can do it, under what authority bank is doing it. Right?
No, bank can withdraw its incentives at any point. Not incentive. These are not incentives.
Incentive, right from the beginning, incentives. It is a reimbursement. They are incurring cost, we are reimbursing it. It is not tagged to the salary. If we place the salary certificate of the secretary here, my lord, then you might find these things are not there.
Newspaper is in the form of parks.
No, not parks.
Perquisites. Cannot be said to be inquisitive. How can it be an incentive, Mr. Sina?
Perquisites and allowances are defined in the service rules.
Show me that, Mr. Sina.
Our service rules is there.
Yes. Show me. Mr. Explain to me. Yes.
My lord, may I look into chapter 5?
Yes.
What are the incentives? What are the allowances?
Yes.
The bank has termed it as allowances.
Bank has termed it as allowance.
Page 5, last word. Page 5, last word.
Word we have used, my lord. Yes, he himself said interchange word. My lord, can you look into chapter 5?
The last word of page 5 of the opposition.
Chapter 5 is the allowances, what they can get, statutory allowances.
Yes. So these are allowances?
This is not allowances. It's not covered there.
What are these?
These are the allowances, but this is not covered there. Chapter 5. If you come
so if it is not covered in allowances, it becomes an incentive.
I'm coming to that. That is the word used right from the beginning. It is reimbursement. My lord, kindly come to the chapter 5. Then my lord, come to perquisites. Chapter 6. What are they entitled? That is the right. Chapter 6 are the perquisites. And my lord, there is chapter 5 is allowances, which does not capture these things. Chapter 6 is the perquisites, do not capture these things. And right from the beginning, it was given by a reimbursement. If we incur petrol, he is entitled to 40 liters. But if he incurs the cost of 20 liters, he'll get the only 20 liters.
Very well. You preparing a chart, come back.
No, my lord, one thing is that, my
No,
lord,
I
last
mean,
time you asked me important questions, my lord.
Yes.
That who, under what authority, what
You show me on the next date because today there is no time. That's why I've said that I'll not take with the other matter. You come back with a chart. At 3, your matter is fixed. Next Friday.
only thing is that, my lord, sir, build up the content, my lord. Only I will possibly.
If you are not here, Mr. Sinha, I will take up other matters.
No.
If you are
But that
not
will
here,
not
I
happen.
when did I not accommodate you, Mr. Sinha? I had also indicated to Mr. Mojumdar that I am placing this matter in the list, but if Mr. Sinha is not ready, I will fix it on another date. That's why I asked you, are you ready? You said you are ready. So,
I tried to call him up last night at 9 o'clock, and I got the information he does not take up calls in the night because he goes off to sleep early.
No.
But I'm surprised he has come ready.
He gets up early, maybe very early.
Maybe. But in the morning, I also called him.
Not early, my lord. A old person cannot go early. So,
Ashwin.
no, I'm ready with the matter, but only
Yes,
thing
I
is
know.
time constraint. Because it
Or
is
Mr. Sinha, learned advocate, represent the
matter is
petitioner,
such a sensitive-
represent the respondents, State Bank. State Bank of India lists this matter for further consideration under the same heading on পরের সপ্তাহে দিয়ে দাও at 3.
Unfortunately, my lord, that is not possible, my lord. I will be ready, my lord. He will
And if
take-
you are not there, I will accommodate you.
My lord.
Notwithstanding marking at 3. Mr. Mojumdar is the last person to insist.
No, in the absence of other side, no, there is no question.
And what is the use? Because I have to hear him at the end of the
I have, my lord, in this case,
He reminded me of the matter yesterday. And you see, there are matters and we tend to always not remember. But he reminded me of the matter that this matter has been heard but not been concluded. So I thought it is best that I conclude this today.
he informed me, my lord, I was not at home, then I got the message.
Your matter on the next date. Because today I have said that I will only take up this matter. It is 3:30.